Aloha, this is Professor Wes Porter. This is our Federal Rules of Evidence. Today we're talking about Rule 103 having to do with rulings on evidence. It's one of these preliminary rules in Article 1. Uh, only comes up for a few reasons, and it actually provides some information to people learning the rules about why we do it the way we do. And it's got a couple terms in there that you ought to be familiar with going forward. Rule 103 for me starts with Part D, as you can see here. What's the goal of what we're trying to do at trial? To the extent practicable, the court must try to conduct trial so that inadmissible evidence is not suggested to the jury by any means. So we're using the rules and the court's rulings on evidence with those objections is to try to prevent inadmissible stuff from getting before the jury and being within the jury's ears. So that's why we're doing this. And then the rest of the rule really has to do with when you want to preserve an objection. If you don't win at trial, what do we require of you? And the important part that I want to talk about here is thinking about an offer of proof, thinking about a motion to strike, or as we talk about throughout the entire course, an objection. So, so pulled out from this rule, I want to talk about three terms that come from the rule. And really objection, which we work with throughout the entire course, motion to strike or moves to strike, and then offer of proof. You should know what all three of those terms mean, and obviously they all relate to each other because they're in this rule having to do with rulings on evidence. Part A of the rule, 103A, really just has to do with, okay, if you're going to object or if you're going to move to strike, we got to make sure that it's timely, for one, that's capital A, A1A, and then you have to state a specific grounds. We have to know why you're objecting. If you go and watch trials, unfortunately, in our courts and even in our federal courts that are governed by the Federal Rules of Evidence, you hear objection without anything more. Sometimes it's acted upon, sometimes it's not. But to be safe and to make sure that you are doing all that you can as an advocate, specifically as an opponent, you want to say objection at the appropriate time, at the most timely time, and you want to say objection, then have a basis. And the bases go with the articles of the rules of evidence. So it's objection irrelevant under Article 4, objection improper impeachment under Article 6, objection hearsay under Article 8. That's why we're doing that. That's why we're offering that basis, because to claim error on appeal, that the court got it wrong and that there should be some relief, you have to do so with a specific ground so it's clear. Timely, I can really help explain a motion to strike by timeliness, right? If the question that the proponent is asking, the proponent is the one putting on evidence, presenting evidence, that the question to the witness calls for inadmissible testimony, calls for some information that's inappropriate for the jury's ears, then a timely objection is before the answer, after question and before the answer. And I want you to think about objecting is you have a buzzer to ring in, just like Jeopardy, right? And the buzzer that you can ring in is standing up if you're seated. This is most courts. It could be the third word of the question and the question's 10 words, stand up. You're letting everyone in the courtroom, most importantly the judge, know I have an objection here that I'd like to be heard. And then when the question is done from the proponent, as opponent, I've already stood up, and then I say objection and my basis. Objection hearsay, objection improper opinion, objection irrelevant. So I want to do that right after the question. That's timely, and to make sure the answer doesn't start coming out of the witness's face. Now, sometimes the question is entirely appropriate. The question doesn't call for an admissible testimony or something that's inappropriate for the jury's ears. It's the witness does it on their own, a very blanket question, and the witness goes sideways and the witness starts to talk about things that are inappropriate. Well, at that point, you still have a duty as the opponent to offer a timely objection. And that's when you hear the inappropriate stuff, you stand up, objection, sorry to interrupt the witness, motion to strike. Now, as a practical matter, really it's just the words motion to strike land in the transcript. We're not actually striking anything, but it's an opportunity to tell the court, and then for the court, if appropriate, to tell the jury, that was something that you shouldn't hear. That was not right that you heard that. And if it rises to the level where it's impactful, it could be the basis for a mistrial or other remedies. So you're going to object as opponent, or you're going to move to strike if it already came out of the witness's mouth in a timely way with a specific grounds. Now, an offer to proof is something a little different, and that is I want you to imagine that the proponent has a whole line of inquiry that they're about to go into. They think they're able to ask the next 20 questions of the witness to go into this whole new area. And right at the front end, right upon the first question, there's a timely objection by the opponent, objection irrelevant. And let's say they make their way over to the sidebar and the parties argue, and the judge essentially rules this objection, this relevance objection is sustained. And you're not going to go into those areas, and the testimony is not going to be admitted in before this jury. Well, just imagine the appellate court reviewing that for error, right? They can review an objection, but reviewing that situation for error, they don't actually know what the proponent was going to go into. They don't know what was going to happen with the questions and answers over the next 20 questions. So on the record, but outside of the earshot of the jury, the proponent can come forward and say, Your Honor, may I make an offer of proof? And the offer of proof is, I was going to ask these questions, I was going to get these answers, and if possible, you can have a little mini reconsideration and say, and it's relevant because now that you know all of it, now that you've heard my offer of proof, Your Honor, would you like to change your ruling? Often that's a no. There's a more formal way of doing an offer of proof. You can have the jury excuse. You can have the witness on the stand. You can ask the questions and get the answers and have a full transcript of what would have gone into, and that's a question and answer offer of proof. But remember, objections, that's what we talk about throughout the whole case. There's a reason why you're doing it. There's a reason why they have to be timely, and there's a reason why you have to state the basis. Motion to strike, if something already comes out of a witness's mouth, and that's the objectionable part, you're not only objecting, but you're saying strike that inappropriate information. And offers of proof, if a proponent gets shut down in a direction where they were planning to go, to make sure the record, to make sure the transcript reflects where they were going to go after being shut down by an objection in a ruling, they can make what's called an offer of proof and let the appellate court know exactly what they would have gotten into.